Good morning, Your Honor.
Good morning. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record, please.
Laura Garcia.
All right, you may proceed.
Ms. Garcia, tell the judge how you know Ambrosio,
Ambrosio is my son.
okay, and you know that he has applied for probation, but the state's opposed to that application, and you're here to ask the judge to grant that probation. Is that correct?
Yes, sir.
And what would you like her to know about Ambrosio?
That he stands that he did wrong and that he's willing to get the help he needs and take whatever proceedings the judge asks of him.
All right, I'm sorry. If we could go off the record for a moment. So when I'm reviewing the TAP evaluation in the pre-sentence investigation report, it has attached to it as a plea bargain agreement, a cap of 5 years. I don't think that belongs with this.
No, Judge.
No, Judge, that's not it.
So with regards to the plea bargain page that's attached to the pre-sentence investigation report, do both parties agree that that is incorrect?
Yes.
Your Honor.
All right. So according to the plea bargaining agreement, in this case, what the court has is you all have agreed to a cap of 10 in the prison. There's a $5,000 fine. The state is opposed.
Pause right here. This is a critical courtroom moment most people miss. When the judge clarifies that the state is opposing deferred adjudication, that's huge. Deferred adjudication isn't probation. It's a chance to avoid a conviction entirely if conditions are met. The state saying no means they believe prison is on the table from the start. Here's the question for you. Should first-time offenders ever get deferred adjudication in cases as serious, or does the nature of the crime outweigh a clean record? Drop your thoughts below.
To the application for deferred adjudication. Is that correct?
Yes, Judge.
All right. I'm sorry for interrupting. You may proceed, counsel.
How do you think this happened with Ambrosio?
He just happens to do wrong, and best thing I can say is that he was on the wrong side at the wrong time, and I guess he just caught up to him.
When we spoke beforehand, you had said something about you believe that curiosity was involved.
Yes.
Okay. And we think that got the better of him at that time.
Yes, he did.
And are you willing to support him, help him in any way you can if the judge was to grant him probation?
Yes, sir.
Ambrosio did have a job when he was arrested, is that right?
Yes.
And he had that job, I think, either right before or right after graduating high school, is that right?
Yes.
And of course, he lost that employment as part of his, after he got arrested.
Yes.
Are you concerned about if the judge is granted probation, are you concerned about him being able to get a job and pay this $5,000 fine that they're asking for?
Money wise, yes. The job, I know he could get a job.
I don't have any other questions. I don't know, Ms. Brown.
All right. Any questions?
Just very briefly. And it's Ms. Garcia.
Yes, sir.
Just gonna ask you a couple of questions. Do you understand the charges that your son has pled to?
Yes.
And you understand this wasn't just one image or just accessing a website. This was him actually possessing multiple images of child pornography. Do you understand that?
Yes.
Do you think it's important that he takes full accountability and doesn't diminish what he did?
Yes.
That's the next one.
Any further judges?
All right. Thank you so much for coming in and giving me some insight into it. Thank you.
Thank you.
Any other witnesses, counsel?
Mr. Cabrera.
Sir? Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Ambrosio Cabrera.
All right, defense, you may proceed.
Ambrosio, did you graduate high school, is that correct?
Yes.
Okay. And where did you used to work?
Right before my arrest, I worked at a place called Their foundation repair,
And what
but I
kind-
had some other jobs for that.
and had you ever had trouble finding a job before that?
Um, there have been instances, but I got a job at the end of it.
Um, I think in the PSI, there's a reference to the officer who did your interview asking why you hadn't sought any kind of treatment. And you and I talked about that. What would you like the judge to know about why that hadn't commenced or why you hadn't received that?
Judge, when the probation officer asked me why I hadn't received treatment, I told him that treatment, psychiatric help costs money, and ashamed as I am, I am, I, I was afraid to even leave my house to go to the front yard to even take out the trash. And
Well, tell the judge why you felt that was.
I was ashamed, ashamed for my actions, and my neighbors, they saw everything. They saw that my house was, they did, I had a search warrant for my house, and I was ashamed to have my neighbors see them. But regarding not even treatment costs money, and
This testimony is uncomfortable, and it's supposed to be you're hearing shame, fear, and isolation collide in real time. But legally speaking, remorse alone doesn't equal mitigation. Courts look for action, treatment, accountability, and timing. Waiting until sentencing to explain fear can feel too late in the judge's eyes. Be honest. Do you hear genuine accountability here or desperation after consequences finally arrive?
it's even harder for me to even ask for a job.
That because you know they're going to see your background. Is that what you mean?
That they would see my background from the background check, that afraid for my safety, that perhaps coworkers might find out about my charges. And I would say that if I wish that I had hope that I can have counseling to ask about things regarding getting a job.
And you agree that you should have some counseling?
Yes.
Now you never had an inappropriate relationship, did you?
No, sir.
Okay, so you just possessed images,
Yes, sir.
and have you had an adult relationship?
Yes, sir. Yes, sir.
And is that still ongoing or
No, sir.
right now? You're willing to abide by anything the judge would require of you if she were to grant you probation?
Yes.
And you understand that you would have to register annually?
Yes, sir.
And do you have anything else that you'd like the judge to know before she decides what to do?
Judge, I'm so sorry. I wish that I could change my time. I'm ready to accept the consequences.
Nothing further, Judge.
All right, any questions?
Okay, great, Judge. Mr. Cabrera, do you understand that the children in these videos are victims who are being sexually abused when the content is made?
Yes.
You understand that every time you view, download, or share those videos, that child is being re-victimized?
Judge, there's no evidence of any sharing.
Sister.
Your Honor, this originates from a NICMIC report where it was uploaded to Snapchat, Your Honor, so.
All right. The objection will be operable. All right. Any further questions? And how old are you?
22, Your Honor.
All right.
guess.
All right, any argument?
Judge, Mr. Cabrera is a young man now. He was even younger a couple of years ago when this came to pass. And I think he's a person who, if you've read I know you have read the PSI, readily admitted his responsibility, came forth and readily accepted responsibility when he was given that opportunity. He waived indictment. He came to court. He took his plea. He showed up here today, despite knowing that he might go into custody. I think he is not a hardened criminal. He has zero criminal history other than this one case. And I don't think prison is an appropriate environment for him, and it might be actually a dangerous environment for him. So we would ask the court to consider it based on all the circumstances and the lack of history that you grant him deferred and give him whatever conditions the court finds appropriate.
Here, counsel. State.
Judge, while this defendant may take responsibility to enter a waiver plea on this case, that waiver plea wasn't something that he just entered, letting the court punish him to the maximum with the state charging the most thing. It was a bargain between the state. We waived certain counts, we waived certain enhancements, and he entered into a plea that he thought was in the best interest of him in this case, that we all agreed was a good option. However, that plea is not for him to be agreed on probation. It's an opposed verb. Now it's deferred, not probation. I should be clear on that. The content in this, we have videos of children, a video of a child under the age of 10 being sexually abused. We have images of children being sexually abused, as well as images of them nude. These children are actual victims. Just because I don't know them, just because they're not here in this courtroom, they're actual victims. This defendant participated in their victimization by viewing, downloading, etc. this material. It's a serious crime. Just because it's his first crime doesn't mean it's not a serious crime. Just because he's not physically abusing these kids himself doesn't mean he's not victimizing them. So given the severity of the crime, given the severity of the content, and given the danger that it poses to the community, that if he's looking at this material online, what he could do in the future, I would ask the court to follow the agreement. I would ask the court to sentence him to the maximum under the plea agreement of 10 years.
Judge, may I respond briefly?
Yes.
There's no evidence at all that Mr. Cabrera believed that anything other than these children were victims and taking responsibility for that. There's
8 years, not the 10 the state wanted, but far from leniency. This tells you exactly where the court landed. Acknowledgement of youth and no criminal history, but zero tolerance for the harm involved. This wasn't a compromise. It was a message. And watch what happens next, because the courtroom doesn't slow down. One defendant leaves in chains, and another case immediately steps forward. Different crime, different story. Same judge, same system.
I mean, everything that the state has pointed out to me is all the more reason why he needs to get the treatment that he provided under supervision of this court. And as you know, under supervision of this court, he would not be allowed to be freewheeling on the internet anyway. So we would again ask the court to grant him deferred, give him the treatment that he needs and any other appropriate conditions that he deem necessary.
All right. So I've heard the argument of your counsel, listened to witnesses, and I take everything under advisement. I'm taking your age under advisement. What the court is going to do, the court will find you guilty. The state is asking for 10 years. Counsel, do you want to address that?
Grant him probation, I would certainly ask for something closer to the minimum. I mean, given the absence of any other previous problems and not trying to discount what he did, I still think that 10 is more than necessary.
All right, and state, I know you're asking for 10.
Okay.
All right, the court is going to sentence you to 8 years in the prison, give you credit for any time served, and there's to be Chapter 62 registration. All right, thank you.
Thank you, Judge.
Oh, I'm sorry. Did you review the trial court certification of defendant's rights to appeal with your attorney?
I haven't opened it, but I
we said.
Okay.
All right, it's telling you whether or not you have a right to appeal. Because this is a plea bargain agreement, you do not have the court's permission to appeal. And because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right. Good luck to you. Okay.
Can I leave, please?
Yes. Are y'all ready to proceed on the motion? All right. The court is calling 2016 CR 5076 State versus Eleanor Arzola. Can I have parties announce?
Rick Pena for the state of Texas. John Pettis for defense.
And are you Miss Arzola?
Yes.
All right. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Eleanor Arzola who was placed on deferred adjudication in 2016 CR 5076 for the offense of burglary of a habitation on August the 22nd, 2017 for a period of 3 years and extended for a total of 6 years? Is that you?
Yes.
All right, state.
Yes, Your Honor, we're here this morning on state's motion to enter adjudication of guilt and revoke community supervision. Violation of condition number 46. On or about the 7th day of August, 2025 in Bexar County, Texas, the defendant, Eleanor Arzola, did then and there fail to comply with biweekly urinalysis on IVR line in violation of condition number 46.
How do you plead to that? True or not true?
The state will waive the other violation.
Any objections?
No objection, Judge.
Did you understand by pleading true to violation of condition number 46, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition 46?
Yes.
Court will find violation of condition number 46 true. Is there a proposed agreement?
There is, Judge.
And what is the request?
Their agreement is to revoke her probation, adjudicate her guilty, sentence her to 2 years TBC.
All right. Has she done anything on probation? Other than just being on probation?
She went to my office with that. She's completed patterns intervention. She's completed a significant amount, Judge. Addiction just got hold.
Probation?
She had been felony drug court for a little while.
Mm-hmm.
She did complete 123 days in my office. She did a outpatient program as well, BIPP or parenting class. Oh, I'm sorry, the BIPP, it says there was a violation of program or services, but the my office complete. There's some classes but complete. It was on the GPS for a while. That needs to be complete as well. Total credit of $129 for her assessed fees of $5,154.
All right. The court is going to grant the motion. The court will sentence you to 4 years in the prison, give you credit for any time served, credit for any time served and successful completion of inpatient treatment. So if she was placed in the facilities and she successfully completed those, she'll have credit for those. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes. Oh, yes.
All right. Because I found you guilty and because I've revoked your deferred adjudication, you do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Do you understand? And I'm going to also request a therapeutic community for you. I can request it for you, but you're going to have to request it as well because I do not have the authority to force them to place you in that program. Once you're released from the prison, if you can't find a sober support house or anything of that nature, just let me know and come back here and I'll pick up the phone and call someone to see if we can get you help. All right.
Thank you.
All right.
Maybe.
Yes.
Judge.
Yes. Hello. Oh, thank you for dressing appropriately for court. All right, the court is calling 2025 CR 006931, State versus Amber Marino. Can I have parties announce?
Lauren Espinoza for the state?
Thirty votes here for Ms. Madam.
And are you Miss Marino?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Ms. Marino, did you review the application for deferred adjudication with your attorney?
Yes.
Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, are you waiving the reading of the indictment?
I am, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Marino, did you review court admonishments with your attorney?
Yes.
Did you understand it and sign it in all the appropriate places?
Yes.
You're charged with criminal mischief, $2,500 to $30,000. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering into this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 2 years in the state jail facility, and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, she has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, I do.
Ms. Moreno, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, there's to be a $1,000 fine probated. The state is recommending deferred adjudication. There's to be restitution to the complainant in the amount of $1,764.08. Did you understand that to be the plea?
Yes.
Defense?
Yes.
State?
Yes, Your Honor, can it just be noted that this restitution has to be split amongst 3 co-defendants, so I guess joint and several liability for that restitution amount?
All right. So here's the thing with that, and I think your attorney probably explained it to you. If there are other people who are part of this, all of you owe that amount.
Yeah.
If for some reason, if it's involving let's say it's involving a total of 3 people, I don't know how many people that are alleged. If 2 people decide they're not paying it, then you have to pay the entire amount. Do you understand?
Yes.
So I know that sometimes when people enter pleas, in their mind, they'll say, oh, let me divide this restitution amount among 3 people, and then I only owe that amount. Do you understand?
Mm-hmm.
Now, if the other parties are paying their sum, the person that's owed this money, they're not going to be able to get $1,764.08 from everyone. It's just, that's the total amount. Do you understand?
Yes.
All right. Does that clear everything up, State?
Yes.
All right. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions? Outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There be a TAP evaluation, 100 hours of community service restitution, no contact with Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yeah.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
Yes, state offers what has been marked as State's Exhibit 1.
No objections, Your Honor.
All right, and state, you may be excused. You're welcome. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing? Anything you wish to say on behalf of your client?
Yeah, we spent a lot of time yesterday, going over everything, and she's agreed to accept responsibility. I time to plead guilty, and I suggested to her to plead guilty, because she is guilty, rather than try to hide behind no contest plea. So that really demonstrates an acceptance of responsibility. A situation where she was just overwhelmed by what was going on in her life, and something snapped yesterday. I really characterize this as average behavior. She's never been in trouble before, 22 years old. So we've asked the court to give her a chance on deferred and follow the plea agreement.
Okay, you say she's 22? All right. So let me ask you, who is Roman Villarreal to you?
That's my boyfriend.
All right. And your relationship to Valerie Marino?
That's my sister.
All right. And how old is your child?
She's 3.
3? All right. So let me explain something. And this is what I would always tell my clients who are on the CPS side, right? When people have a child together, that's the person you chose to have a child with, right? It's very important that you're able to co-parent, because even though you're no longer with that father and maybe you've moved on with someone else, your child still needs to see what healthy relationships are. And I know your attorney is saying this is out of character, but if you can just internalize and think about how your child was feeling with all these adults, these grown people just screaming. And this is what I've learned. And you've done family violence cases. This is what I'm sure your attorney has probably told you. If he hasn't, I'm going to tell you. During child exchanges, unless this is like a Hallmark movie, don't bring your significant other with you for a child exchange. I have never seen that work out well. So by the same token, if the father of your child is coming to pick up his child, he shouldn't be bringing his girlfriend with him. And if you're going to pick up your child, you shouldn't be bringing your boyfriend or new husband or whoever it is with you, because tensions just rise. And if there's an issue where people are concerned about their safety during custody exchanges, that's when you say we're going to meet at a substation or meet at the police. You understand?
Yes.
But from reading everything, I see that there were issues going on, and maybe the child needed help and all of these other health issues going on. So the $1,000, how much are you able to pay per month towards that? And here's the thing, give me a reasonable number, because sometimes people think I want to hear, oh, I'll be able to have $1,000 in 20 days. If that's not you, that's not you. It's just that I'm going to be placing you on deferred adjudication. I'm going to grant your application, but you're going to need to be able to let the state know, and I'm sorry, the probation officer know how much reasonably you can pay a month, because this has to be paid off. And since one person is your sister, the other one is your boyfriend, you know, usually your mother will say, hey, you better help your sister pay this off. So reasonably, what do you think you can pay per month towards this amount?
I can do 100.
Okay. All right. And was CPS involved at all?
No, Judge.
All right. This is what the court is going to do. The court is going to sentence you to 3 years deferred adjudication. Are you employed?
No.
All right. So how are you supporting yourself?
Well, I'm getting child support, and
Mhm.
my boyfriend would be the one to
financially.
Okay, here's the thing that, as a side note, you never know if a boyfriend is going to be around for the long haul. You never know if somebody has a girlfriend, if they're going to be around for the long haul. So you need to be able to say, because you have a child, you need to be able to say, you know what? If he were to leave, how am I going to support myself? Will I be able to provide a roof over the head for me and my child? You understand?
Yeah.
So you have to calculate that. All right. In this court, I require that people have employment. All right. So there's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. There's to be restitution of $1,764.08 to the complainant. Are you all able to do child exchanges at a location different from this location?
She'll have to answer that, Judge. I don't know how she's doing that now.
We're doing exchanges at the police station on Sesame.
Okay. All right. So for now, you can't have contact with that specific address. State and the complainants don't want her back at the address, correct? All right. So you can't have any contact at that address. If there's an emergency that comes up with your child and it's at that address, then you'll probably have to call the police or somebody for a welfare check. Your attorney will let you know what to do in that situation. Okay.
Okay.
So there's to be no contact with the location. And at some point, if things go well, the complainants may decide that it's okay for you to have contact at that location. All right, there's 100 hours of community service restitution. I'm going to order anger management. Once you've completed anger management, 50 of those hours will be deemed satisfied. And the remaining 50 hours will be satisfied once you've completed parenting classes. And I'm going to order parenting classes. Field visits 1 time per month for 3 months. And there's $1,000 fine, and that will be probated. And restitution is to be paid at $100 per month. Probation, is there anything else? No, there wasn't a request for a no contact with him. Just the address.
I have one more thing, Judge.
Yes.
What would you set the supervisory fees at? Set them at the minimum because of.
In regards to that, legally, now that they've changed things, she'll have to fill out a form.
Okay.
And once she fills out that form saying that she's indigent and provides proof, I'll receive notice of that. And then I'll be able to make a decision on that.
And can she get that form from probation to fill out?
Yes.
Okay. Thank
All
you.
right. And what I can tell you, supervisory fees, they help probation run their operations. Okay.
Okay.
All right. Is there anything else you need from the court? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yeah.
All right, we can go off the record. Here's the thing: to be successful on probation in this court, communication is key. If you have an issue, let probation know about it. If you feel they're not addressing it, you can always come back to the court and address it with me. Do you understand?
Yes.
All right, good luck to you. Make better decisions, okay?
Thank you.
All right, you're welcome. Thank you, counsel.